I'm going to introduce now Professors Petar Kragić and Professor Diana Jerolimov, who have for us a presentation which is very nicely entitled Judicial Sale of Ships, International Comity versus Sovereign Control. Professors, the floor is yours.
So good afternoon. It's not easy to take a floor, or in the new parlance to take a screen after Anne and Juan presentations, which gave so many information about the convention. So only what can I do, and together with Diana, to tell you what we don't know about the convention and our dilemmas related to it. So bear with us and learn about our not knowledge or our lack of knowledge. Let me just say it's International Comity versus sovereign control. So the globe is intertwined and crisscrossed with all types of relations, including those of trade and commerce, but divided among the nation states. In the mid-19th century, Friedrich List argued that the international trade should be regulated by international rules, even though nowadays there are international bodies that bring about international rules. No international body has power to enforce them, as such power lies with the sovereign nation states. The only way to enforce a judgment is through its recognition by the state in which territory enforcement is required. Foreign judgments might be based on foreign law, substantive international rules, and substantive and procedural international rules. This is the case for our convention. Now, the process, another thing which I would like to emphasize, it is the note which you see, this sign. It means that Croatian delegation intervened in the working group. So, who we want to protect? The process starts with the arrest of a ship. On one side, we have the creditors who suffered loss or damages. On the other side, we have a buyer which is willing to pay the price and acquire the ship. So when I joined the working group, my impression was that the instrument might be quite complicated and impractical because too much emphasis was put on protection of the creditor's interests. I was vocal in favor of simplifying the process of notification and grounds for rejection of recognition. But over time, it seems that the sentiment shifted too much towards protecting of the purchaser. And now the interest of public claims appear as well. The shift could be seen in a notification, avoidance or suspension of sale, and ranking of claims. So in the revision number 2, judicial sale was defined as a sale of a ship by a court of other public authority or any other way, which the proceeds of sale made available to the creditors. But at the same time, it had another provision which said that the convention shall not apply to the judicial sale of a ship following confiscation of the ship by tax, custom, or other law authorities. Now the problem is that we crossed this subparagraph out, so it is deleted. And because of that, there was intervention and proposal to confine the judicial sale when it's done for the purpose of recovery of private and commercial claims, for which the proceeds of sale are made available to the creditors, which implies that it would be ranked, that they would be ranked by the maritime law. And then we added, say, for the costs and expenses related to the procedure. Of course, always something is deducted to cover the expenses of the procedure. Now, why this was proposed? Because if you look at the maritime liens list, you won't find claims in respect of tax, custom, and state dues. Or if you look at the arrest convention, again, maritime claims, no claims for tax and custom dues. So if we have authorities, state authorities, whether it is tax authorities or custom authorities, and they arrest a ship, say, for allegedly smuggling, and they want to get money. What they do? They try to sell the ship to a purchaser. So what they have to do is to go to a court or other public authority, and then the ship would be sold by public or private sale under the supervision or approval of the court, and then proceeds of the sale have to be given to the creditors. But now, in this position, you, or on the current draft, you can argue that the taxman is a creditor. So if he takes all the money for himself, then the convention would apply, and the authorities of the state of sale would be able to issue certificate of sale to the purchaser, who then will be able to register the ship under register in a foreign state. Or you can argue that if you have a private creditors, that the money has to go to them as well. But basically, again, if one single dollar trickles down to the private creditor, then again, convention will be applied. Now, the question is, did we or do we want this result? Because you see the shift from the original draft where all public claims have been excluded. Now we are going to the other extreme where everything is accepted. Well, at this point, I can just say that the proposal was supported by the CMI and rejected by the American delegation, and nobody knows why, because it was not properly discussed at all. So I think this is something that should be addressed, and we should be aware of the consequences under the current draft, and whether leave it as it is, but knowing what we are doing, or change it somehow. Doubt notification. Under revision number 2, you have an article on notices. So it said, well, who are the notifying parties, the governing law, which is the law of the state of judicial sale, and the minimum content, which is prescribed in Appendix 1. In addition, there would be no effect if the requirements in Article 4 were not met. And the question always in a legal document is who is going to control the whole process, which court would have jurisdiction, and it is clear that jurisdiction goes to the court in the state of judicial sale. Now, just to summarize, so we had notified parties, minimum contact, no international effect, law and jurisdiction prescribed. And there are some other provisions which survived all the changes and reached revision number 4. The notice shall also be published by press announcement in the state of judicial sale and transmitted to the repository. And upon receipt of the notice, the repository would promptly make it available to the public. Now, the question is, and I think this is the most important thing which bothers us, is what happens if there is no transmission to the repository, or if the notice is not published by the repository? The answer is absolutely nothing. And we think that in a legal document, if you have an obligation set forth, then there must be some consequences attached to that. And I think now at this stage it is lacking. So we have obligation with no sanctions, with no consequences whatsoever. But we shall come back to that. When sale has no effect, revision number 2, it was quite complicated because it listed the parties or persons who had rights to apply for denial of recognition. And then we have a fraud, which is committed by the purchaser. Of course, all these things are for the domestic court in the state of recognition, because whether it's a public attorney or somebody else who could as well apply for denial of recognition, or as fraud is committed by the purchaser, that could be fraud committed by anybody else. And if a clerk in a state of sale commits fraud and issues clean certificate, then I think there is no reason why that should be limited only to the purchaser. And the effect would be manifestly error to the public policy. So the scope of application as it stands now is just that the ship was physically within the territory and the clean title is conferred. And we have the denial of recognition. Only one ground remains, and this is if the effect of the sale would be contrary to the public policy. So you will see that in Article 10, all other requirements have been deleted. Only what survives is the public policy. What's the role of the repository? The proposal is that all notices, certificates, notices of cancellation, and notices of suspensions are transmitted to the repository, and that the interested parties may apply to the or may refer the competent authorities of the state parties to the notices indicated in paragraph 2. Now, if we go back to Article 10, and then we have the proposal is that we have the Article 3 and Article 12 as conditions for the, or as the grounds for for denying recognition. So the Article 3 is the ship is physically present and the clean title confirmed, and Article 12 is that notification is done through the repository. So what all of this boils to is which court would have right or jurisdiction to decide of that. If could be the state of judicial sale or court in the state of judicial sale, or it could be the court in the state of recognition. So we might leave conditions under 3 to the jurisdiction of the court in the state of judicial sale. But if in the Banana Republic, but a clean certificate is issued, but it is manifestly that the ship was not by any reasonable standard present in the state, or certificates imposes some burdens on the title, then that will be against the public order. So I think still the state of recognition could call the public order. For example, if interested parties could demonstrate by the records of global positioning system, logbooks, witnesses, information from other ports, that the ship was not within the territory of the state of sale, regardless that that issue was decided otherwise in the state of the judicial sale and the clean certificate issued. I think still we should give that right to the court in the state of recognition to take his own view on the complaint. So the proposal is to allow the court of in the state of recognition to check whether the ship was physically present and clean title given, which is very easy, and that notification through the repository has been properly done. So on notification, we can get a very elegant balance. On one side, the court in the state of judicial sale has jurisdiction on notification matters. But the court in the state of recognition could very easily check whether notification has been done through the repository, which enabled interested parties to learn about the sale in any part of the world on any device. Of course, caveat creditor principle would apply. So what's the problem? At the moment, the arrangements with IMO have not been completed. And another issue might be that the IMO would not like to take a liability for publishing the notices and all other information. But it's very easily solvable. For example, if authorities in the state of sale transmit the notice to the repository, and in the repository, omits to publish it on the internet, then it's very easy that the authorities in the state of sale could see it, that on the screen their notice was not published. They will call up the repository and say what's the problem, why the notice was not published, and the problem could be ratified within minutes. So I think that it is very important, and we could give now some legal consequences to the notification through the repository, because it is very easy to establish whether or not notice was published on the internet and when. Another proposal was that we could make this provision conditional. So it would come into force if a convention is completed before the arrangements with IMO have been done. Then it could say that this article would come into force once the the arrangements have been completed, and the notice of the United Nations Secretary has been given to all the parties to the convention that the notification through the repository then would have the consequences for application of the convention. Avoidance and suspension of the sale. Again, in these two paragraphs, the jurisdiction goes to the exclusive jurisdiction to the courts of the country or the state of sale. But it's of interest are these number 3 and number 4, paragraphs number 3 and 4. Judicial sale of a ship shall have no effect if sale is avoided by the judgment which has no longer subject to appeal. The problem is that it would take quite a long time before the final, all the appeals have been used and exhausted, and we have the final judgment. So I think this number 4, the effects of a judicial sale survives. It's very important because the certificate could be issued and injunction as well applied for to stop the effects of the certificate, because new evidences have been in the meantime discovered, which for whatever reason could invalidate the sale. At the moment there is proposition to delete this paragraph 4, because they say in no case is it identified in which the effects of the sale have been suspended after completion of sale. But even completion of sale has been done, and before the certificate is used for registration, there could be an injunction which would then stop the use of the certificate. And number 5 is very interesting, and this is what was explained to the delegates, that the convention cannot go into effects of avoidance of the judicial sale. It should be left to the domestic law of the sale, of the state of the sale and the state of recognition. Whether the sale, if the sale is avoided, whether only damages would be awarded, or whether the ship will be given back to the original owner, and so on and so forth, and what would be the impact between these two jurisdictions, we cannot solve it through this convention. And now just a couple of things on definitions. Charge. We have here the charge is the right of use, and we then propose that the bareboat charter, it would include a bareboat charter that survives the sale, and this was rejected on the grounds that the right of use actually implies the bareboat charter that survives the sale. But because of all these issues, I think that would be a good thing to emphasize that the bareboat charter is part of the right of use.
Mr. Kragić, I'm sorry to interrupt. I was just told that we have more or less 10 minutes to go.
I will end just a couple of slides. So the ship means any ship or other vessel registered in a registry that is open to the public inspection. The question is, registered in a register of a party state, or in a state whether is a party of the convention or not. And I think this should be resolved. And if we accept this second solution, that the party of the ship could be even registered in a state which is not party to the convention, then we would have a problem of deregistration of the ship, because the country of register would not accept the certificate. Scope of application. So the question was raised then by the chair, whether this means that in general, if under the law of the state you cannot get always the clean title, then the convention would not apply, or only in a particular case, if you do not get the clean certificate, only then the convention would apply. So the suggestion was that the state of the judicial sale after completion, if it in a particular sale issued certificate which gives clean title to the ship or the purchaser, then in that case the convention would apply, regardless or not whether in principle the law of the state of judicial sale might or might not allow some notices or some qualifications of the title. When the certificate would be issued, the only way is that we leave it to the law of the state of judicial sale. And the solution is that only when, under the judgment in the state of sale, you can register the ship in the domestic register, only then you will get the clean certificate which you can use in abroad. Basically, what it means is that convention should not go into that matter and leave it completely to the state of sale. Now, definition. We have definition of certificate, and the draft refer to the certificate of judicial sale. Certificate of judicial sale referred in Article 5, or just certificate. The proposal would be that we define it. So we would have the certificate, means certificate defined in Article 5 below, and then you can use the term and write it with a capital C, and you don't need to have different terms in reference to the certificate. And now you might ask why all these different proposals were not properly discussed, or reasons were not given for exceptions or rejection and so on. And I can only refer to the very old saying. Thank you.